We have spent a lot of time focusing on the rights that are specifically written down in the Constitution. One of the biggest controversies that has gone on for a long time and is really at the forefront of American politics right now is the idea of like, what about unstated rights? So, what about rights that people don't have specifically mentioned in the Constitution? So in 1965, Justice William Douglas was the first to really use a scientific term to imply that there were rights that individuals had that weren't specifically listed in the Constitution, but could be implied from things that were there that you had. So that term is referred to as a penumbra, which is usually a scientific term that is the shadowy area that's produced by an eclipse. And he thought that was a good sort of analogy to make because he thought that there was like some of the Constitution's not black and white. There's like some gray area. And it was his belief that there are rights indeed that Americans have that aren't specifically mentioned in the Constitution, but are sort of implied from things that are mentioned. So, the best example of this is the right to privacy. You could look through the thousands of words that are listed in the Constitution, and the word privacy is not listed once. Um, but there are those that argue, right, that privacy is an implied right in the Constitution. So, like, why is it implied? Well, they would argue that there are a handful of amendments that deal with the issue of privacy, despite the fact that privacy is not specifically addressed. So, for example, the First Amendment gives people freedom of speech. So you have privacy sort of over your thoughts and your political expression. Government can't prevent you from saying what you want to say. You have freedom of religion, so that there's privacy in your religious thought, right? Government can like form their own religion and force you to join it, and they can't prevent you from exercising your own sort of like religious views as well. Or the Third Amendment, which is not like a super relevant amendment today, but it prevents you from having to open up your home to soldiers and to quarter them like the colonists had to back in colonial times, to house, feed, and clothe, take care of soldiers because that's like your private dwelling, or like search and seizure rights, right? That you have a right to your property, you have a right to your person without it being unfairly searched by like law enforcement. So there are people that argue that okay, yeah, privacy is not specifically listed in the Constitution, but it's clear that the founding fathers cared about privacy because all of these things involve privacy rights. So, like, how does this end up like manifesting itself in like modern times? Well, like issues like abortion. Like in 1973, the Supreme Court ruled that women had a right to pursue an abortion if they wanted to. There's nothing in the Constitution that specifically addresses the issue of abortion, and this is part of the controversy. But it was implied that the founding fathers obviously thought privacy was important, and it was extended to like decisions involving your own body. So, by extension, the Supreme Court in 1973 legalized the right to abortion because of these unstated privacy rights. Or, for example, in 1965, the Supreme Court ruled that states like Connecticut that had outlawed contraception were violating your constitutional rights. There's nothing in the Constitution that deals with the issue of contraception specifically, but again, it's related to a matter of privacy involving your own body. Or controversially, like right to die laws. Oregon was one of the first states that basically allowed patients that were given terminal illness diagnoses from doctors to basically solicit the help of a doctor in ending their life early so they wouldn't have to experience the pain and suffering that was coming at the end of their life. Again, there's nothing in the Constitution that addresses this issue specifically, but this is a related matter of privacy dealing with matters regarding your own body, or even like spousal partner relationships. So, for example, in 1967, Supreme Court ruled in the case of Loving v. Virginia that Virginia's interracial marriage laws that still were in the books in the 1960s were unconstitutional. That you couldn't basically, establish laws that prevented an interracial couple from getting married. Or in 2015, the Obergefell v. Hodges case, which basically said that state laws that prevented same-sex marriage were unconstitutional because these matters of relationship were private matters, and the government saying otherwise was discriminating against them. So that's why these unstated rights are significant, because they're used to deal with lots of these modern day sort of like issues. So, which brings us to modern times, right? We know that in 2022, the Dobbs v. Jackson case overturned Roe v. Wade, basically saying that there's nothing in the Constitution that can be directly interpreted to protect the right to an abortion. That if states want to allow abortions, states can allow abortions, but that there's nothing in the Constitution that federally guarantees or protects the right to an abortion. So, like, the significance of this is, are we looking at a turning point in sort of the Supreme Court's interpretation on unstated rights? Is this beginning to change? Supreme Court's position on this for like the last 50 to 60 years has been that like privacy, this unstated right, can be used to deal with a whole host of like issues. Are we now looking at a court that is less willing to accept these unstated rights as being federally protected?